out to her. So a week later, the employer finds out about this and fires him. And the bartender files a unfair labor practice charge with the National Labor Relations Board. And this went to a decision, and this was closely analyzed, and the board decided this is not protected concerted activity. So again, we have two things. We have a customer issue, and we do have a workplace issue. The customer issue about calling the customers rednecks and saying, I hope they choke on glass, that's clearly not protected. The complaints about, I haven't gotten a raise in 5 years, I don't think I should have to help the waitresses, that's talking about workplace conditions. The question about that is that concerted or not? Well, it's not concerted explicitly because the board, explicitly said the stepsister is not an employee there. It's just a relative. So he's talking to a non-employee. But the question is this implicitly concerted activity? That is to say, and let me do this. Let me fast forward to this. When is an individual complaint concerted? So this was clearly an individual complaint, just him and his stepsister. But that's not the end of the analysis. When is an individual complaint concerted? And here are some questions to ask. Is it engaged in with other employees? Well, here, no, it's not. He's the only employee of the bar. Is it engaged in with the authority of other employees? Well, that gets a little trickier. Is it engaged in on behalf of other employees? So, did he say, we bartenders haven't gotten a raise in 5 years and we shouldn't have to do this? Well, he didn't use that language. The key is it cannot be solely by and on behalf of the employee himself or herself. So if the employee is just complaining about some condition that affects him or her individually, that's not concerted. It doesn't have to be explicitly, a dialogue between two or more employees, but it has to at least be on behalf of. Here's a quote from the JT case, that fifth bullet point. Individual activities that are the logical outgrowth of concerns expressed by the employees collectively are considered concerted. So for instance, if behind the scenes a bunch of bartenders had been complaining to each other about we haven't gotten a raise in 5 years, and then this bartender expresses that concern just by himself and brings it to management, which he didn't in this case, well, that could very well be concerted activity, even though it's not explicitly so. Concerted activity also includes circumstances where individual employees seek to initiate or to induce or to prepare for group action, and where individual employees bring truly group complaints to management's attention. So this is, introduces a big gray area, I think. So the question is his complaint about, remember there's at least one other bartender there, so he's not the only bartender. Haven't gotten a raise in 5 years, don't like helping the waitresses without sharing in their tips. Is that, truly a group complaint, or is it an individual? And that's a factual determination for the arbitrator to make. Here he found it was just an individual complaint. That's going to be a circumstantial determination. He came down on the side of, no, he was just complaining about his own personal situation. Therefore, it's not concerted activity, and the employer was within his rights to fire the bartender. So the termination was upheld.
Can I have a question about
Yes,
that?
Sam.
What if he was talking about himself and other bartenders, but he threw in the comment about the customers? Wouldn't it be irrelevant? He could be fired anyway because of the one comment that he made about the customers being rednecks?
Well, then the determination needs to be made about why did the employer fire him, okay? Was it reason A or B, or was it a combination of them? And that's almost always the key issue in any sort of discrimination case. Did the employer fire this individual because she's a woman, or because of her poor job performance, or was it kind of a combination of the two? So, in both the Becker case and in this case, the employer, of course, conveniently said, oh yeah, we fired him for the customer complaint, not the other one. Well, the employee is going to say, no, 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 not the case. You fired me for the other one, but not the customer thing. So, you know, it comes down to a factual determination about what was really motivating, subjectively motivating the employer at the time the termination decision was made.
Do you know if, given the notice in the case, if the other bartender was ever subpoenaed to give testimony about his workplace?
I don't think so. I don't think so. And there even was evidence in here that I think a few weeks before, he and another bartender had complained to themselves about this issue. But the arbitrator here found that his complaint to his sister-in-law on Facebook a few weeks later was independent of that conversation. It didn't arise out of that conversation. So the bottom line is that the arbitrator said this was purely an individual personal complaint, and therefore there's no protection to it. The fourth and final case I want to talk to you about is Hispanics United of Buffalo. This was a not-for-profit company in Buffalo, New York, that provided services to financially underprivileged people in Buffalo. And there was a caseworker who was not an employee who would come in there once a week, and one night off, one night at home, I think about 4 or 5 Hispanics United employees. One of them posted something about, this caseworker comes in here and makes all our jobs tougher. Well, that opened the floodgates, and all of a sudden you got 4 or 5 employees complaining about this person doesn't hold up their end of the bargain, she makes our jobs harder, and just complaining about people at work, and ultimately making it harder for them to do their jobs and provide the services to the people who receive them in Buffalo. Well, the employer saw that, and skipping ahead to the last page, the board called this a textbook example of an illegal firing, because they were complaining, and I think there were even some 4-letter words used. Doesn't matter, says the law. So there was some rough language, and they were on Facebook having a very public employer bashing session about the conditions of employment. But what they were complaining about was a textbook example of workplace conditions. This coworker's lazy, not doing their job, and it makes it harder for us to do our jobs. So that what they were complaining about was clearly workplace conditions. There were 4 or 5 employees having a dialogue, so it was clearly concerted activity. And it was abundantly clear that that's why they got fired. So an unfair labor practice was found here, and not only that, but as I said, the National Labor Relations Board called this a textbook example of what an employer is not supposed to do. Yes, Michelle?
I have a question. What about the employee that they're talking about? I mean, what if that employee goes to their HR director, let's say they are a friend of theirs on Facebook, they see all these things that are being posted about them, they go to their HR director and say, they're talking about me, they're calling me these names, I want to file harassment against them. I mean, is there slander protection for that employee that's being discussed on Facebook?
Yes. In this case, there wouldn't be any slander or harassment, I wouldn't think. Harassment needs to be based on a protected characteristic. So if you're being harassed because, I'm not saying you personally, but if you're being harassed because you're lazy and you're not carrying your load and you're making everyone's job harder, that's not protected. The law says there's no protection for that. So you can be harassed.
It's more of a matter of opinion.
Well, no, I'll get to that. Harassment is only protected, or it is only prohibited if it's based on race, gender, sexual harassment, racial harassment, religious harassment, and theoretically national origin harassment, disability harassment. If you're in a wheelchair, people can't make fun of you all the time because of that. But it has to be based on one of those protected reasons, either under federal or state law. So being lazy is not a protected class like race or gender is. So unfortunately not. So there's not going to be a protection for that. Slander is going to be there as something to protect the person, but slander only applies to statements of fact. Okay, so if these people are bashing the person because they're expressing opinions, opinions being this person is lazy, this person doesn't work hard enough, those aren't statements of fact, those are statements of opinion. Now, if they said something about, if they made up something and told lies about, I saw this person, stealing from the accountant's office last Tuesday, well, that's something where, the slander is going to step in and protect the employee if it is in fact untrue. So yes, those protections are there, but as you can tell, the law is protecting. The law wants to make it a priority for employees to be able to openly voice their concerns about the operations of the company, their workplace conditions, how they're paid, their benefits, etc. Because the National Labor Relations Act protects this collective concerted activity. And some things are going to suffer as a result. So that's what I wanted to talk about concerning protected concerted activity. Another key thing to keep in mind, especially with HR folks, is the employee handbooks. Most of the time in employment law, the law has a no harm, no foul view of things. Okay, so for instance, if there's an illegal policy, for instance, if there, let's say theoretically in the employee handbook that says we only hire white men here, okay, not that any employer would be stupid enough to publish that, but that in and of itself is not going to give any individual standing to sue and say they've been discriminated against, okay? Now, if a woman or someone who's not white applies for a job there and doesn't get the job, well, she's going to have pretty much a slam dunk case with that sort of evidence on her side to support her claim. But that in and of itself per se has not harmed anyone, has not caused anyone harm. So the law is going to say no harm, no foul. The same thing applies to the common misunderstanding of interview questions. If you're interviewing a candidate and the candidate gets asked, what religion are you? And then the hiring manager is, theoretically foolish enough to say, I don't like people of that religion. Well, the employee can't stand up, walk out, and file a charge of discrimination, file a lawsuit, and win, because there's been no harm. Being asked a question, being made a comment to, does not cause you any harm. Now, as I said, if the person doesn't get the job, they have a pretty slam dunk case after, with that sort of evidence on their side. But, asking an inappropriate question, making an inappropriate comment during an interview is not per se illegal. And that's usually what employment law says. Here, it does not. So the board is being very aggressive. And